upon the consolidation of three petitions. For purposes of this hearing, the issue is, or the court will consider the challenges to the ballot title and ballot measure summary proposed by the Attorney General's Office regarding Initiative Measure 1631. The court has received and reviewed all of the pleadings and, of course, the law. The court has thus far devoted a lot of time, effort, and thought into these issues. The court is going to hear from all the parties, of course, but it occurred to me this morning as I was driving to work that maybe there is some utility in asking the parties, if not encouraging the parties to, and allowing the parties to have an opportunity this morning to meet and confer, to have an opportunity to discuss all of these issues before the court hears from the parties and then makes an ultimate ruling. In this court's experience, whether it's a civil case or a criminal case for that matter, it makes sense in some cases for the parties to have a meaningful opportunity to meet and discuss and attempt to resolve as many issues as they can before the court makes a ruling. The court believes in this particular case there might be some additional utility to that proposal because as the parties are aware and as the court is aware, this ruling from the court this morning will be the ruling of the court. So do any of the parties think that there is any merit to the court giving you 15-20 minutes or so to meet, confer, see if there's any agreement on any of the language?
Your Honor, sponsors would be happy to meet and confer with other parties to see if we could come to an agreement.
How about you guys?
Your Honor, I agree that it would be productive to see if we could reach some agreements.
Okay.
Your Honor, Peter Gonick for the Attorney General's Office, and I don't know if it might be helpful if Your Honor were willing to identify some of the areas that the court found particularly persuasive, because there are very many different approaches, I guess, and objections to the current ballot title. If there were specific areas that the court were particularly interested in hearing the parties' approach, I think that could help direct the discussions.
I appreciate that invitation, and I respectfully look at it from a different perspective. The court's perspective is that if I were to identify what the issues are the court is focusing on or wishes input on, it might, for lack of a better word, taint or send a message to the parties of which way they need to go. I want the parties to have an opportunity to hammer out as many issues as they can. And then if there's an agreement, that's great. If not, any agreements that you do have, we can reduce to writing. Then I'll hear arguments on the matters where there is disagreement or still an issues, and then I'll make a ruling. So how about I give everyone until about 9:30? Is that enough time? You need more time than that. I have time this morning. So. What do you think?
That seems better.
Why don't we start at 9:30, and I'll take the bench again at 9:30, and if the parties are making some progress, I'm amenable to giving the parties more time. If at 9:30 it appears as if the parties need the court to make a ruling, then the court will hear from the parties and ultimately make a ruling. So the court's going to be in recess until 9:30. Thanks.
All right. All rise. Court is in session.
Please be seated. Happy to stay up. Would you guys like more time? I'll give you more time if you'd like.
Your Honor, I think I speak for everyone, but I don't think we're going to come to an agreement.
Okay.
So I don't know that that would be productive, but we certainly appreciate the opportunity and we made the effort.
Okay, I appreciate that.
Thank you, Your Honor.
Okay. So the court will hear first from Mr. Wong. Good morning.
Good morning, Your Honor. Once again, Greg Wong from Pacific Law Group on behalf of the initiative sponsor. Initiative 1631 is an initiative of the people that, if it gathers enough signatures, will appear on the November ballot. The initiative is 38 pages long, and in some respects, it's complex. But at its heart, the initiative reflects the people's desire to address one thing, and that is pollution. And it does so in two different ways. First, 1631 charges a fee. It charges that fee on businesses based on their carbon pollution contributions. That fee both generates revenue and serves as a deterrent to future carbon pollution. Second, 1631 uses that revenue. It collects from the fee, and it funds investments that reduce pollution, increase environmental resiliency to pollution, and also addresses the impacts of pollution in our communities. And there's three broad buckets laid out, and this covers numerous pages of the initiative. The buckets for investments are the clean air and clean energy investments, and examples of items in that are things like renewable energy projects, energy efficient buildings, sequestering carbon. There's clean water and healthy forest investments. This helps restore marine habitats, it improves stormwater treatment infrastructure, and it promotes forest health to increase resiliency to wildfires. And the final bucket of investments are the healthy community investments. And this helps communities better deal with increased wildfire and sea rise risk, and also funds education programs to help promote strategies and educate strategies to reduce pollution. So the question before this court is how, as the court knows, a very limited number of words, the measure should be fairly and accurately described to voters. It'll be up to the voters to decide whether this is the right policy, the right way to address pollution, whether it would be effective or not. But that's a decision that's made at the ballot box. Today, we're just looking at what is the notice that needs to be provided. The statutory standard is laid out fairly clearly in the RCW in 29A 72050. There it says that the statement of subject, it must be sufficiently broad to reflect the subject of the measure and sufficiently precise to give notice of the measure's subject matter. Then that statement of subject is followed by a concise description, which must be a true and impartial description of the measure's essential contents, and it must clearly identify the proposition to be voted on in a way that does not create prejudice for or against the measure. The general goal here, and of doing the ballot title, is to give notice. It's to give notice to inquiring voters so they would know to look further regarding the details. The Supreme Court has said ballot titles need not be an index. It need not provide specific details of the measure. What we're going for here is understandability. Do we have accurate, fair language that's understandable to average voters and gives notice of what the measure aims to do? Now, the sponsor agrees that the Attorney General did a very good job of drafting the ballot title and agrees that it's a good start. But there are some refinements that the sponsor would request in the ballot title and summary to make those descriptions more accurate and better fulfill the statutory standard. So on the statement of subject, sponsor is in full agreement with the Attorney General that the statement of subject here is pollution. As described, the measure concerns the introduction of pollution into our environment, reducing pollution, and investments to address the negative impacts of pollution. The stated intent, if you're a voter of inquiring mind and you actually go and look at the measure, it tells you that the people's intent is to quickly and effectively reduce pollution and address its negative impacts. And there's been some suggestions that's artful drafting of some kind, and that's just not the case. This is about pollution. It's a straightforward subject. It's one of public concern, and it's one that makes sense for the people to wish to provide direct legislation for when it feels the legislature has not acted in the way that it would like it to. It's also the most accurate term here. pollution is broad. Pollution has to do with both introduction of pollutants into the environment and also their continued presence in the environment. How do we address the pollution that already exists? And once again, the structure of 1631 that focuses a fee on the actual carbon pollution emissions, and then also provides significant provisions for investments related to pollution, follows that broad definition. Pollution is a commonly used term. Governments use it from the federal, state, and local level. It's used in laws, it's used in agency names, it's commonly used by media. It's not a prejudicial term in any way. It just is what it is. It's pollution. It's pollutants that have a harmful effect on the environment. And so here, the statement of subject of pollution best gives that broad notice that's required. The statement of subject is really thought of as a topical subject. It's very high level. It's something that just would give the inquiring mind at least the taste of what it is that this measure is about. So moving on to the concise description, there's 5 changes that sponsors suggest. The first one is removing the quotation marks around the words pollution fee. The words pollution fee, that's an accurate statement. This is a pollution fee. It's a fee on carbon pollution. But the use of quotation marks here is confusing. It's also partially inaccurate because pollution fee is actually not a defined term in the measure. If you go to the definition section, there is no pollution fee definition. So by putting quotation marks in, it's a little bit unclear to the average voter why they exist. I mean, and this isn't to suggest the Attorney General meant this, but I could see somebody reading that and thinking the quotation marks are kind of like air quotes, right? It's a pollution fee. And that could create prejudice for or against the measure, and also is just confusing. The Attorney General has stated that the quotation marks are there to help give notice so that the voters would know to go look further about what pollution fee means. And there's a better way to actually do that, and it's a way that the Supreme Court suggested in the Washington Association for Substance Abuse and Violence Prevention case. In that case, there was a fee, and the fee, the Supreme Court looked at the ballot title and looked to see, was the way the fee described misleading? That is, is this an accurate, fair statement of the fee? And it said when the language that is included that says the fee, what it's based on, and the words based on were important, then that is what gave notice to the voters that they could go and look further. And this leads to the second change to the concise description that sponsors advocate for, which is the words based on should be included. This is a pollution fee, and it's based on carbon pollution. In the Washington Association for Substance Abuse case, the issue there was the liquor privatization initiative that was on the ballot a few years ago. And that initiative did a number of things, but it also imposed a charge on every sale of liquor in the state. And it was tacked on to each individual sale. The ballot title termed that as a fee based on sales. Supreme Court said, that's accurate, it gives notice, it's fair, let's use that. It was upheld against a subject and title challenge. The court should do the same here. This should be a fee based on carbon pollution. The third change that sponsors request is, it seems like it would be most helpful to voters to also know who is actually paying the fee, who's the fee payer here. It's not required by law, but it seems like it'd be helpful. When you look through the list of who the fee payers are, it's power plants, refineries, importers, distributors, and sellers. These are all companies, businesses, and you can't really do a laundry list in the ballot title only because you have a limited number of words. So the question is, how do you best summarize those types of businesses and companies? Large emitters is the term that the measure uses, and so it seems to be a fair one here. I could see using businesses or companies, or even this may be an appropriate place for quotation marks because it is a defined term. So large emitters with quotation marks around it perhaps would be something that would make sense. The fourth and fifth requests are ones that there wasn't significant briefing against. The describing investments broader, once again, very important in this measure are the investments. And so it's somewhat prejudicial to focus so much on the fee and not give as much to the investments. And the Attorney General makes that point, I think, clearly. Sponsors suggest that clean energy is a better term than renewable energy because it's broader and it's, once again, something that people understand, it's commonly used. But also, renewable energy, if you couple it with reduced pollution as some of the investments, is something that may be workable. And then finally, to save space and to allow for the language to focus on what the fee is based on, climate change impacts can be changed to climate impacts, and once again, the Attorney General agrees that that is just as informative and useful and accurate language. Turning to the summary for the ballot measure, the same issues, I won't repeat them here, but our suggested ballot title language incorporates those same issues. You also have a few more words, you have 75 words, and so once again, thinking about how important the investments are in this measure, figuring out how pollution is actually addressed in the environment and how it can be reduced. Those broad investment areas in the initiative should be reflected so voters know this is going to clean air and clean energy programs, clean water and healthy forest programs, and to support healthy communities. The two other suggestions to the summary that sponsors request, the wording on utilities, there's a utilities credit function in the initiative ballot measure. The word avoiding was put in, and that's not correct. That is misleading and prejudicial because the large emitters who are paying the fee are allowed to essentially do direct payments that fund the same types of investments under an approved plan. And in doing so, if they do that and use the money that way, then they can take a credit for the fee they otherwise would be liable to the state for. So it funds the same investments, it's just a direct payment. So it's a fee in lieu of, a payment in lieu of the fee. And in terms of the scope of consultation with Indian tribes, we pointed out in our briefing, the Attorney General once again agreed it was more accurate to say that really the only projects that are affected are ones that are where consultation comes in, or where an Indian tribe is directly affected or directly impacted. And nobody disputed that in the briefing, so we request that change is made as well. The language that sponsor puts forward in its proposed order is the most accurate, the most informative, and most fair language for voters. This is about giving notice. It's about being able to address what the measure says it's going to do, and then we're going to leave it to the voters, into the campaign, into the public healthy debate that surrounds ballot measures to say whether this is effective, whether this is correct, and whether this is actually the people's will. If your honor doesn't have any questions, I'll save the rest of my time for rebuttal.
Thank you, Mr. Wong.
Thank you.
Mr. Moss?
Good morning. Good morning, Ron. I'm David Moss on behalf of petitioner Gary Christensen. I think in light of the discussions we had during our dialogue before argument this morning, I think it makes sense for me to focus on three issues, which I think are three of the four, which if the court resolves these issues, the parties could come to an agreement on what remains. I'll just say the fourth issue, which I think Petitioner Morgan has an issue with, is whether the initiative uses the term tax or fee. I'm going to set that aside and leave that for him. So the first that I think the court needs to take up is whether in deciding the best way to fairly and accurately represent Initiative 1631, the court should remove the overbroad, inaccurate, and misleading term pollution and pollution fees, particularly from the statement of subject, but also the concise description and ballot measure summary. The second issue is that the court should ensure that voters are given a sense of the magnitude, the actual costs imposed by the revenue generating side of Initiative 1631. That scale, that magnitude of cost, that matters to voters, it matters to Washington businesses, and it belongs in the concise description or the ballot measure summary. It was in the title of the predecessor to this initiative, which was Initiative 732 on the November 2016 ballot, and it belongs in this one as well. And the third issue is that the statement of subjects Petitioner Christensen believes needs to in some way demonstrate to the voters that at its core, Initiative 1631 is a revenue generating mechanism, whether it's termed fees or a tax. 1631 is going to generate a significant revenue for the state of Washington, and that needs to be captured either using the term fees or tax in the statement of subject. During our colloquy, I suggested that perhaps using a conjunctive in the statement of subject would allow for a broader term after the conjunctive to cover the spending side of this initiative. In other words, the statement of subject, which can be up to 10 words and is currently only 1, could say something along the lines of Initiative 1631 is a measure concerning carbon fees, and then the spending side could be summarized as spending with this revenue or something. We didn't get to the point where we were negotiating that additional conjunctive, but I think that if the court decided that's how it should be termed, we could then negotiate what the other side of that conjunctive would be. I think that the revenue side needs to be captured by the statement of subject as general taxation measures are, or fee measures. That's what Initiative 732 said in its statement of subject, that concerning taxation, and this one should as well. Now I want to return to the first issue, which is the use of the term pollution. I think pollution is a grossly overbroad term for a statute of this nature. While I don't want to get into the substantive argument of whether carbon dioxide is a pollutant, I don't think that that's a discussion we need to have today. I think it's fair to say that pollution covers far more than carbon dioxide, and carbon dioxide is far from what people naturally think of when they think of pollution. The public discourse, the debate about whether carbon dioxide is contributing to global warming is a recent development. Many people absolutely consider carbon dioxide a pollutant, and it should be something that's considered in the media, in the public discourse around Initiative 1631, but it shouldn't be described to voters as an initiative concerning pollution, when what it concerns is a very, very narrow chemical, carbon dioxide. In addition, the initiative doesn't actually place fees on carbon pollution. The fees are based on carbon content, the content of a fossil fuel, not the amount of the emission. So to describe it as concerning pollution, or that it is a pollution fee, is misleading, is actually taxing carbon content, which is why Petitioner Christensen suggested that the use of carbon fees would be accurate and not misleading to voters. And Petitioner, the sponsors of the bill suggested that that pollution is not a prejudicial term. I think that while that's sort of a clever way to avoid the issue, pollution is absolutely a negative term. I don't think that the sponsors would debate that. And whether or not carbon dioxide is considered a negative term, it's certainly not as negative as many of the pollutants that people naturally think of as pollution. You can think of things from carcinogens, from asbestos, or chemical compounds that are dumped in the environment. And those absolutely are toxic chemicals that people have to leave their homes because they're emitted in their communities. People absolutely have the right to distinguish between a law that's going to, for instance, prohibit, outright prescribe certain pollutants from use or from emission in the communities or in the environment. There needs to be a way to distinguish from that and from a regulation on the use of a certain compound, a very specific one, carbon. And to the extent that the statement of subject is going to capture the nature of this bill, it needs to include carbon, which is the specific compound that this bill regulates on the revenue side. None of the petitioners here today, nor the AG, debates that on the side of revenue generation, the only substance at issue is carbon. So the issue in terms of the statement of subject is whether carbon fees, that the issue they take with that, whether carbon fees covers the spending side as well. And council indicated that their concern is that if we use a conjunctive, the initiative might run into a subject and title or a single subject challenge on the other side. I respectfully disagree with that concern if the title were to be carbon fees and a sufficiently broad term to cover the whole spending side. At that point, I don't think anyone could credibly challenge that the title accurately and completely captures the content of the bill. The second point I want to focus on, that I think if the court resolves the parties' good of these four issues, if these four are resolved, I think the parties can come to an agreement on what remains. The second is that the magnitude, the actual cost of the bill, make it into the concise description of the ballot measure summary. 732 had a starting fee akin to this initiative, and it was contained in the ballot title summary. It listed the starting cost, and this one should as well. When you look at the movement towards a carbon tax or a carbon fee law around the country, and I think it's important to think about that there is a movement towards that, and this would be the first carbon tax or carbon fee law in the nation, and other states are looking to Washington. We don't want to be a state that duped its voters into putting a carbon tax or a carbon fee on the books. Voters should decide that they want a carbon tax or a carbon fee. And I'm here to say today that Petitioner Christensen genuinely wants an accurate ballot title and ballot measure summary. As a member of the Association of Washington Businesses, there is not a formal policy position yet on the initiative. The purpose of Petitioner Christensen's ballot title appeal is to get an accurate summary and title to voters so that the vote reflects the people of Washington's decision on whether to be the first state to have a carbon tax or a carbon fee law. The third point, again, is that the statement of subject should include an indication that this is a revenue generating measure. That's fundamentally the most important. That's the core, the heart of Initiative 1631. And voters deserve to know that. They deserve to know that this will generate a huge amount of capital for the state that's going to fund either the spending programs that are contained in this initiative, or, as I indicated, if those are appropriated away, it'll fund something else. But it's going to be a funding initiative, and that belongs both in the statement of subject, either in the term using the term fees or a tax, and in the concise description. Unless the court has further questions, I've asked to reserve any time remaining for debate.
Thank you.
Thank you.
Mr. Morgan. Good morning.
Your Honor. Just for the record, my name is Glenn Morgan. I'm here as a pro se litigant speaking on behalf of myself. This is my first time doing something like this, so I realize I'm in a room full of professionals and I'm the amateur here making the argument here today. I really want to emphasize, I think the biggest, I agree with much of what Petitioner Christensen has said regarding the critique of the content of the concise statement and certainly the summary. I think we would find a lot of common ground there. The biggest difference, I think, is my argument that I believe that in order for this initiative to be represented accurately to the people, that it should be called a tax. And I think that I'm going to focus a little bit on that argument. I did in both the original challenge that I presented and the reply. And I think it's important that we emphasize that. I think it's deceptive and disingenuous to call it a fee in this case. For clarification, for the court, I had submitted an OFM, Office of Financial Management, financial analysis of Senate Bill 6629, which was submitted by Senator Erickson, which incorporated the language of I-1631 in it, largely what that tax does. And the reason why he had submitted it is that the Office of Financial Management is obligated then to do an unbiased analysis of the actual costs of this initiative to the taxpayers, how much they would actually be paying. And I don't know that I referenced that clearly. That's why I submitted that as an exhibit. But and based on that analysis, it was $5 billion in taxes that would be collected over the span of 10 years. That is definitely not a fee. That is an order of magnitude beyond just an average fee that Olympia might pass on occasion. This is a substantial amount of money that comes out of the taxpayers. Ultimately, the taxpayers are paying for this. And to me, it seems that that's it just is, we're obligated to honestly and accurately represent this for what it is, which is a very substantial tax. I-1631 also, I believe, fails the Koval test, Koval versus Seattle, in every way. The revenue that's generated from this is not used to regulate a targeted industry at all. It's used just for general welfare programs for the good of the community, or at least a very broad list of things that these tax dollars in theory are distributed towards. Everything from forest fire prevention to helping people who are put out of work as a direct result of this tax. And that widespread use of the tax dollars really argues against calling it a fee. It's really being used the way that tax dollars are oftentimes used. And the revenue collected through it is just being spent so broadly and so widely as to be almost meaningless to say that it's in a targeted way. There's also, as mentioned in the Koval test, and it comes up periodically, that there's no direct relationship between the fee that's charged and the service that's received. So usually a fee is charged in industry, and then there's some regulation of that industry that's done with that fee. The majority of fees that are collected by the state that are actually defined as fees are used in that manner. And in this case, it's used just as a tax. In fact, it doesn't matter how much pollution is put out by any of the, they can call them large emitters or whatever they might be. There's no, if they capture the carbon and actually produce zero pollution of any kind, they're still taxed the same amount, because it goes back to just taxing how much carbon is in the fuel. And I had mentioned this before, and this case has come up, the Washington Association for Substance Abuse and Violence Prevention versus the state. All of the parties have referenced this in their replies. And I mentioned the Wiggins dissent in that. And I mentioned that primarily because he mentioned, and this fact was not disputed by the majority in that case, that the subject and title rules prevent the type of artful deceptions illustrated by the initiative sponsors, I believe, in this case. And what they decided there was that it was too late to dispute the initiative. It had already been passed by the people. And so in those cases, great deference is given to what the voters already had decided. And, but he did reference that using this term fee to artfully disguise what's actually a tax to the people is a real problem. And I think when Chambers joined with him in that dissent, I think it's very important to look at that. Tellingly, the sponsors of this initiative, as I referenced in my original challenge, called it a tax in their own literature. In fact, after I referenced that in my original challenge, a few days later, all references to taxes on the sponsor's website was scrubbed. And so I think that also illustrates that most people recognize this as a tax. All references to this initiative by media or commentators throughout the state and around the country who are looking at this call it a tax. In fact, the only place this is called a fee is within the language now of the initiative itself. The second part, I think, that supports why we should call it a tax versus a fee, just to be more honest, is that we want to really try to avoid encouraging artful linguistic distortions in the future that would allow somebody to present all kinds of wonderful and grand schemes and calling them something that they're not. The AG justifies their ballot title in summary by saying that the majority of the initiative is about how to spend those tax dollars, not about how to collect the cash, and therefore the title should be about how the money is spent. And the supporters justify calling it a fee because they use the word 86 times in the document as they referenced in their reply, and therefore it must be a fee because they call it a fee. The problem is if this court is to rule against calling it a tax, which it demonstrably is, and calling it a fee based on those above justifications, then it creates an absurd result. And I think I know there's an absurdity doctrine where you can't have law that's going to produce results that were never intended. Obviously, if that's how the court rules, every tax initiative in the future will be drafted to sell the sizzle and ignore the cost. Like a cheesy timeshare sales pitch, today it might be $5 billion in taxes, tomorrow it could be $50 billion. But if I only spend a couple sentences talking about how much I'm going to collect this cash and through taxation, and 90% of it talking about how wonderful all these great programs are I'm going to build, then if we're just doing analysis that way, we're going to produce titles that are very misleading to the public and would require them to do an extraordinary amount of research, which is unrealistic, to determine what the real costs are. And I think it's incumbent upon us to represent it accurately and honestly. This is the only time that we'll get a chance to challenge this. I think the supporters have referenced that there's a future time to challenge whether it's a tax or a fee, but as the case in the Wiggins dissent referenced, There is no other opportunity. The decision today is going to be that decision. We have to resolve it now. Again, as the Washington Association for Substance Abuse and Violence Prevention versus State case clearly shows, there's never going to be another opportunity. And it's just too big, with too much of an impact on the average person, to hide the true cost and true nature of the initiative from people. And I have been influenced in discussing this with some other people here earlier and reading some of the other briefs. And I think that, well, a tax must be in the very title so that the voters know what they're voting on. In the interest of compromise and staying within that 10-word limit that RCW 29A 72050 subsection 1 indicates, there probably does need to be some reference to how that money is spent, something like a tax on carbon and suggested spending of these taxes, I think would be a good compromise there. But the concern over the single subject challenge, I think, is really not warranted. If you're collecting a tax and you're just simply saying how it's going to be spent, logically those two are usually lumped together. And so I think that it would still pass a single subject test if we say it is a tax and we're spending the money, and then people can go and look below. I believe that there's probably a lot of common ground between the Christensen petitioner and myself as far as what the summary and concise statement would be. My biggest disagreement in that case is really an argument over whether it's a tax or a fee. And I think that particularly with the magnitude of the impact and the way this is going to increase everybody's costs of living and traveling, not just myself, but anybody else who lives in the state of Washington, I think that it really should be a tax reference in the title. And with that, I'll reserve my time, Your Honor, for any further rebuttal, unless you have any questions.
I do not. Thank you, Mr. Morgan.
Thank you.
Mr. Gomez. Good morning.
Good morning, Your Honor. Peter Gonick from the Attorney General's Office. We are urging the court to retain the ballot title as written. We believe that it complies with the statutory requirements for each of the elements of the ballot title. That said, there is more than one way to draft a fair and accurate ballot title, and some of the points that have been made by all of the petitioners are valid points. The problem, of course, is that because of the very few words that, particularly the concise description and the statement of subject that we have, if one adds in one area, one has to take away from another area. And that is one of the main concerns that the Attorney General has with many of the, well, all of the proposed concise descriptions, alternative concise descriptions, is that it would not include reference to the oversight of a public board, I can't recall now whether the sponsors include that, but we do think that's an important part of the measure that should be included in the concise description. There are some...
It is in the sponsors, I think, isn't that, Mr. Wong? There's a reference in...
Yes, Your Honor.
Yeah, okay.
Then,
Pardon my interruption.
No, not at all, Your Honor. Forgive me for misspeaking. We do think that is an important part of the concise description. With respect to the Attorney General's briefing, I think has pointed out areas in which we don't necessarily disagree with some of the comments by the petitioners, but again, are constrained by the 30-word limit for the concise description, 75 words for the summary, and that would form the basis of why we don't believe it should be changed. We do think that in general, we urge the court to approach this in a way of, if the existing ballot title satisfies the statutory requirements, to leave it in place unless the court feels substantial improvements could be made, or in other words, if it ain't broke, don't fix it. I'm happy to go through and respond to some of the points that have been made, and first, with respect to whether or not to use quotation marks around pollution fees, the Attorney General does feel that that is the most appropriate way to describe the government charge that is being proposed in this case. It describes it in very few words, so it doesn't use up many of the 30 words of the concise description. It, in the Attorney General's view, in any event, addresses the potential ambiguity as to whether or not this charge is a fee or a tax. And the Supreme Court opinion in Washington Association of Substance Abuse and Violence Protection, I think, makes clear that you don't necessarily have to resolve the question of whether or not legally this is a tax or a fee under the Covell test. Instead, the key question is whether or not the government charge is explained, the scope and purpose of the charge is explained to voters. So in that case, it was called a fee based on sales, and the court determined that, well, whether or not it's a tax or a fee doesn't really matter because the voters understood that it was going to be a government charge that was imposed on the sale of the liquor. The Attorney General's concise description does explain the scope and purpose of the charge, and so we think it's appropriate to retain the quotation marks around pollution fees. If the court were inclined to not want to include the quotation marks, then we would suggest simply referring to it as fees. That as long as the rest of the concise description explained how the scope and purpose of that fee, that would satisfy the test set forth in that Washington Supreme Court opinion with the very long name. And so in any event, we would suggest not using the term pollution fees, as that is not necessarily commonly understood unless it's in quotation marks, which suggests to the voter, I think everybody agrees, it suggests to the voter to refer to the initiative for further explanation of that. We would also disagree with including the term large emitters, as the sponsors have proposed. That term is not a commonly understood term. The definition wouldn't necessarily be what voters would think the term would mean, and so we would suggest that the court reject that approach. One, and here I'm getting into the difficult area of if the court accepts one argument, then it affects other arguments. If the court were to remove the quotes from pollution fees, the Attorney General would agree that putting the quotes around large emitters would probably suffice to let voters know that it's a defined term, but would not recommend having two different terms with quotation marks around them because of the possible negative connotations when you have more than one term in quotation marks. With respect to the issue of whether or not utilities can receive a credit, we think the language as written is accurate. If the court were concerned that it was not sufficiently descriptive, it could, instead of saying to avoid fees, say under certain circumstances or with certain requirements. And not sure exactly how much of the wordsmithing Your Honor would like me to go into. That's what we do when we draft the ballot titles, obviously. We have to take words away in one place, put them in another place, and make sure we use the same number of words. Moving on to some of the other objections by the other petitioners, Mr. Christensen first takes issue with the statement of subject of pollution. In general, the way that we approach drafting ballot titles and the statement of subject is to make that statement of subject as broad as possible to make sure that it covers everything that is going to be in the measure. In part, that's a response to the statutory directive to make sure that it is broad enough. In part, that is also out of concerns of potential challenges down the road under Article 2, Section 19 of the state constitution, that the subject of the measure be expressed in its title and that it not have more than one subject. So we generally try to make those as broad as possible. In addition, the statement of subject always appears with the concise description. It never appears on its own. So the concise description allows further explanation of the general subject matter. So we think pollution is what the measure is about. It imposes a fee on what it calls pollution. It requires spending to address the impacts of pollution, and that's why we chose that word for the statement of subject. We, as stated in the brief, we wouldn't object to calling it carbon pollution. We think that is still sufficiently broad to cover the measure and is slightly more specific and would satisfy at least some of the concerns expressed by petitioners. With respect to the sense of the magnitude of the cost, the Attorney General agrees that that might be something that is important to voters. We don't think there are enough words to put that in the concise description. And even in the summary, although some of the examples that were cited by petitioners were minimum wage numbers and other numbers that have been included in the summaries in the past, the $15 per metric ton is not necessarily something that a voter would be able to translate immediately into, well, how is this going to affect me? I can only speak from personal experience that when you tell me that a fee or a pollution fee is going to be imposed at $15 per metric ton of carbon inherent in fossil fuels, I have no idea what that is going to mean to me. $15 or $5 or even 25 cents. I think I'm not unusual in that respect with respect to what is commonly understood. The question of whether this should be described as a tax or a fee, again, we attempt not to interpret the law when we draft these ballot titles, but by using the pollution fee in quotes, we address any potential ambiguity in that. We do think there is an argument to be made that this is a fee and an argument to be made that this is a tax. It may never be decided because often those are only decided because of limitations inherent on local governments imposing a tax or whether or not it's a property tax, and I don't think either of those would be present here. So it may never be resolved, and according to the Washington Supreme Court, it need not be resolved as long as the voters understand the scope and purpose of the charge that is being made. I'm happy to answer other questions that Your Honor has, but we would ask that the court retain the ballot title.
Thank you.
Mr. Wong, rebuttal.
Thank you, Your Honor. I want to touch on a few of the arguments that were raised by counsel. First, as to the statement of subject, we are in complete agreement with the Attorney General. I think Mr. Gonick expressed it well, that when you're looking at a statement of subject, the goal there is to essentially provide a very broad, topical word that gives the highest level of notice as to what is this measure about. What do all of the parts of the measure, if you look at them all together, what could you say ties them together? And that word here is pollution. And we see this in, for example, any measure, initiative measure that has anything to do with taxes. It could be imposing a new tax, prohibiting new taxes, preempting taxes, changing the tax code or studying it. The statement of subject in those measures is almost always the single word, taxation. This measure concerns taxation. It's high level. It doesn't have to be inclusive of every single kind of tax. The same was true in the 1972 initiative that created many of our laws related to the Sunshine Laws related to transparency in government, the Open Public Meetings Act, Public Records Act, public disclosure requirements for campaigns. There was many, many different things that initiative did. The Supreme Court looked at that in the case of Fritz versus Gordon and said the subject here is open government. It does not need to be an index of everything. It doesn't need to be comprehensive. It just needs to be that high-level statement of what is this measure about. This isn't trying to trick anybody. It's just giving them notice. And so pollution is the fair and accurate way to do that here. There was a suggestion that the use of the conjunctive, using an and, is appropriate here. And once again, we share the Attorney General's concern that when you do that in a statement of subject, that raises down the roads constitutional questions regarding subject and title and single subject under the various tests. I won't go into here, but essentially if there is a list, there may be some likelihood of a court holding that it's a restrictive ballot title, which leads to a more narrow interpretation of those constitutional principles. So here, there's no reason to be overly restrictive. We should be broad. Let's give a fair and accurate representation to the voters of what this is about. You get more details in the concise description, which is on the ballot right next to the statement of subject, and you get more details in the summary as well. As to the sense of magnitude that has been brought up, again, we agree with the Attorney General that here, what does $15 per metric ton of carbon pollution actually mean? Most voters, that's not helpful. Also, I note that the fiscal statement that will be generated by the initiative, it will be in the voters pamphlet as well. It always is. So if some voter of an inquiring mind wants to know what is the fiscal impact here, what are we talking about, it's there in the voters pamphlet, and it informs voters. And also, if there's a place for that $15 per metric ton, and we can see there's some argument that perhaps, at least as an indicator, could be included. It seems the appropriate place for that would be in the summary, where you have a few more words to do so. As to the Initiative 732 was brought up by a couple of the petitioners here, and I just want to really clarify something here. It was termed a predecessor initiative, and that is just wholly inaccurate. 732, not only in the backers of the initiative, were completely different from the backers of 1631, but the measure itself was completely different. It was a way to put a stated tax on carbon in order to remain revenue neutral in the general fund. So it imposed a tax on carbon pollution, and at the same time cut other taxes, sales taxes and other things, to stay general neutral. There were no investments of the broad scope to address pollution, as you see in 1631. And it was all about taxation, so appropriately the title there was taxation. And here the structure matters. A fee here makes sense because we're putting a charge on emitters' carbon pollution, and then we're using that charge to help address the effects of pollution. And that's kind of a classic way of looking at a fee. Also, I think the suggestion that you should look at 732, which had a ballot title that wasn't challenged in a proceeding like this that was rigorous, looking at all these other measures, there's no surprise that carbon pollution is a concern of the public, right? There's all sorts of different measures and ways to go about it. So, but the fact that there's been other measures is not what the statutory requirement is here. We don't take into account the political process or the evolution of different carbon policies. What we look at is what words give the most accurate and fair description of this measure, of what this measure says it's going to do to the voters. It will be certainly in the public debate, certainly in the yes and no statements in support and opposition of the measure, and certainly in voters' minds, whether or not this is the right way to address carbon. But the fact that there was all these other predecessors that relate to carbon anyway, just don't shed any light into what the ballot title here should be for this initiative. That leads a little bit into the tax argument, and the Supreme Court case of Washington Association for Substance Abuse and Violence Prevention is just directly on point. And Mr. Morgan cited to the dissent, respectfully, the majority of that court. The majority opinion controls here, and the majority opinion clearly and directly was faced with the question of, is it misleading to say something's a fee based on sales when the challenge is actually that's a tax? Voters were hoodwinked here. And the Supreme Court said, no, it does not matter. As Mr. Bilnick pointed out, the fee versus tax legal distinction is something that comes up usually if there's a question of local authority, whether or not a local government has authority to impose a tax, or in property tax situations. In the ballot title context, it's not relevant, and that's exactly what the Supreme Court held. The tax versus fee question is not one that's relevant, and even if it were, that's a merits question. That's something that gets challenged after the fact if there's some argument that, oh, this was deceiving, and then that would be a subject and title challenge, as it was in the liquor initiative. I think that there was a suggestion of what to do with the quotation marks on a pollution fee. Respectfully, we think that they should be dropped because they are misleading. It's inaccurate, not a defined term. If I think that we could live with something where if you dropped it, you termed it a fee based on carbon pollution. So if the concern is that pollution fee is not a well understood term, you can say it's a fee based on using the Supreme Court suggestion for the language and then carbon pollution. That could be something that may also be accurate and would reduce the concern of any confusion about what a pollution fee is. But again, respectfully, that doesn't seem like a confusing term. It seems quite accurate for the measure. Does Your Honor have any questions?
I do not.
Okay, respectfully, we ask that Your Honor enter the ballot title in sponsor's proposed order.
Thank you. Mr. Moss.
Your Honor, I'd like to take up 4 points that have become sort of focal in this discussion this morning. The first is the use of the word pollution in the statement of subject. Both the Attorney General and the sponsors have rightly suggested that under the standard, the statement of subject does need to be broad enough to encompass the subject of this measure. But there has been no explanation as to why it has to be a single word. The law gives you 10 words. And the court respectfully does not need to consider in deciding what that subject should be, whether or not the title is going to be deemed restrictive or general or broad for purposes of some potential future subject and title or single subject challenge. There's nothing impermissible about a restrictive title if a restrictive title is necessary to fairly and accurately describe a measure. However, I don't think that using a broad conjunctive term necessarily would be restrictive here. Using a subject, statement of subject that was carbon fees and spending, environmental spending programs, something like that is going to cover, or even more broad, spending, environmental, economic justice programs, something that's broad enough that it covers the full spending side. I don't see how it's not possible to do that in a way that allows the statement of subject to accurately reflect the nature of the bill as is necessary under the standard. And both the Attorney General and the sponsor make the point that the concise description and the statement of subject always appear together. Well, that's true on the ballot. The statement of subject is often used in the press. It doesn't always appear to a voter right next to the concise description. The decision of the court today could impact how this is described in literature that voters see. And if it's described as a matter concerning pollution, respectfully, that's going to be a misleading and inaccurate way for a voter to see the bill that's before them on the ballot. The counsel for the sponsors suggested that often for tax bills, they almost always refer to use a broad term like taxation. And I agree that when there's revenue generation, that should be captured by the statement of subject. So I understand why whenever there is a bill concerning taxation, that's captured in the statement of subject. In fact, I think that supports the point we've been trying to make here, that Petitioner Christensen and I believe Petitioner Morgan agrees with me on this, that that is a key aspect of this bill, the key aspect of this bill for the voters, and that should be in the statement of subject. Whether it's referred to as a tax or a fee, which is the next issue I want to take up, I agree, it's not necessary for the court today to reach a resolution as a matter of law, whether this law is a fee or a tax. Absolutely, that's not at stake on a ballot title petition. However, the court can decide for itself in determining what's fair in describing this to voters, whether or not the court believes this is a tax or a fee under the co-ballot test. Petitioner Christensen stated in his briefing that the way that this bill was drafted has complicated that challenge, both for the Attorney General in coming up with a proposal and for the court by labeling the full text of the statute thick with terminology that refers to pollution fees and fees. That makes it challenging to describe it as a tax, which is why Petitioner Christensen did not ask to change the term from fees to tax. But I think it's important to remember that the decision here today is not a decision about whether this law is a tax or a fee. It's just a decision about how to best reflect Initiative 1631 to the voters. The next issue is the magnitude of the bill. Both the sponsors and the AG indicate that a cost per ton is not something that a voter would necessarily understand. And I'll agree that sitting here today, the voting population in Washington probably does not understand. However, that's a challenge with the carbon initiative because you can't tell a voter how much this will cost them at the gas pump. You can't tell them how much this is going to cost them on their natural gas bill. It's a complicated analysis, and we won't actually know until this plays out. but they will care about how much this is going to cost them. And I don't think you can fairly argue that consumers in Washington won't be impacted by this, and how they travel, how much it costs them for them to get to work, how much it costs them to heat their houses. And that will become a matter of public discussion. And they will understand when they go to the ballots, many of them will understand what $15 per ton means. Because in this national movement towards a carbon initiative, carbon tax, carbon fees, however you want to refer to it, that cost per ton is what is measured by the success or failure of these initiatives, is often measured by how much is being charged. So I think that has to appear in the concise description or the ballot measure summary. Ideally in the concise description, although I concede that that's a challenge given the scope of this initiative, to get it in the 30 words. At a bare minimum, it needs to be in the ballot measure summary. I also want to respond to the point about Initiative 732. I do believe it's a predecessor to this initiative, and I do think that's a fair way to understand it in determining an appropriate ballot title. This would be the nation's first carbon tax, the nation's first carbon initiative. And I-732 was an attempt at that as well. And I will admit that this is a very different looking initiative, but fundamentally, it is another attempt, a repackaged attempt at a carbon tax. And I think that voters deserve to understand that. And I think that you'll see in the way that the sponsors have changed their own image. And I'll admit that it's a different sponsor, but in many ways I'm sure it's the same supporting group. They got creative. Look at the name of the group. It's no longer Carbon Washington, it's Clean Air, Clean Energy Washington, and it's now referred to as a pollution fee, and they're trying to describe the measure in ways that capture pollution as opposed to carbon, and after an unsuccessful effort the first time around, and unsuccessful efforts before the legislature. But I think that the voters need to understand that this remains potentially the nation's first carbon tax. The last point I want to make is just a brief one. I don't think that the AG's opposes, I don't think the term large emitters belongs anywhere in the concise description or the ballot measure summary. It's misleading. It's a defined term, and the definition doesn't even limit it to by size. So referring to large emitters is just going to give a negative connotation. It's also misleading because I don't think you can fairly dispute that this tax would be passed on to consumers. So to suggest that somehow only large emitters are going to be feeling a financial impact of this is both misleading as a definitional matter and misleading as a practical matter. If Your Honor has any questions, I'd be happy to answer them.
I don't.
Then I respectfully request that the ballot title or ballot measure summary proposed by Petitioner Christensen be entered. And if you're not inclined to enter a particular party's ballot title or ballot measure summary, I do believe that by resolving the 4 issues I propose, and others may disagree on which particular issues, but some of those key issues, I do believe that further deliberation after resolution of those key issues could save a substantial amount of work in trying to navigate all of the word limits that the AG appropriately indicated can be challenging. When you add words, you have to subtract words.
Thank you.
Thank you.
Mr. Moore.
Thank you, Your Honor. Without repeating what I had said earlier, I do think that whatever Your Honor, whatever the court decides regarding this title, taxation must be, taxes must be in the title and the concise description in order to be accurate so that people understand what they're looking at. I understand why the sponsors view the word taxes as having a negative connotation. Obviously, I-732, 59% of the voters said no, over 59%. And so as repackaging this under a new initiative and hopefully eliminating the word taxes is an understandable strategy on their part. However, voters do pass taxes all the time. They pass it in a local school and to support their schools, and they don't call property taxes property user fees or property ownership fees. They call them property taxes. Voters are willing to pass taxes if they agree with what the tax dollars are going to be used for. And I think that it's most fair that we make sure the voters understand what this is. There was a reference to for the highest level of notice to the voters because of such an impact that this initiative would have on their day-to-day lives of everybody. There's no way to avoid it. You can avoid alcohol fees or taxes on alcohol by just not going and drinking alcohol. You have no way of avoiding this now if you live and use any kind of transportation or attempt to heat your home. This is something that's going to affect every voter and every resident of Washington State. And so the highest level of notice to those voters, to be fair and accurate with what this initiative actually does, would be to include the word taxes in the ballot title. Not pollution, but taxes. I think that's the most important word. If whatever the court would decide, I didn't bring a motion here, but whatever they would decide, as long as there's tax in the title, I think that it at least would send a notice to the voters in a language that the average voter would understand that this is going to be something I'm going to be paying for quite a bit. I think that the fact that tax dollars are, so much of this initiative deals with how these tax dollars would theoretically be spent by putting them into these segregated funds is not a good argument to support not including the idea of a tax in the title, because those segregated funds get swept all the time. They're so generic in how that money would potentially be used and theoretically be used that I think that it needs to be emphasizing the most significant thing that's actually going to impact everybody who votes on this, and that's the fact that they're going to be paying a tax one way or the other, and a substantial tax at that. I-732 is very applicable, I think, and I'm going to repeat and support some of the things that Petitioner Christensen referenced here earlier, and both in the petition and the reply that he made earlier, and also in oral arguments today. I think we would find a lot of common ground on the summary and some of those other issues. I just think that I-732 is absolutely applicable. The mechanism for the taxation still exists in I-1631. Just because a tax cut offset to reduce the harm that 732 was going to impose on people was proposed in the first initiative. Now it's removed. It's actually a more significant tax now than it was then. If anything, now it's more important to call it a tax, as I-732 was called a tax by the Attorney General originally. And so realizing that whatever the final decision of this court may be on that title, I believe that it just needs to reference a tax so people understand what it's looking at. Everybody's referring to this as the carbon tax. Every outside observers, the media, even the sponsors originally, until I made that point, referred to it as a tax. And I think that as long as it's correctly referred to as a tax, voters will at least have notice that what they're voting on is going to have an impact on them in their day-to-day lives, and a significant one at that. So with that, Your Honor, if you have any more questions.
I don't, thank you.
Okay, thank you very much.
The court is going to be in recess until 11 o'clock, after which the court will take the bench and issue a final order.
All right.
The ballot title reads as follows, will read as follows. Initiative Measure 1631 concerns pollution. This measure would charge pollution fees on sources of greenhouse gas pollutants and use the revenue to reduce pollution, promote clean energy, and address climate impacts under oversight of a public board. The ballot measure summary shall read as follows. This measure would impose pollution fees on certain large emitters of greenhouse gas pollutants based on rules determining carbon content starting in 2020. A public board would supervise spending the revenues on reducing pollution, promoting clean energy, and addressing climate impacts to the environment and communities. Utilities could receive credits for approved investments. Indian tribes would consult on projects directly impacting their land. There would be periodic reporting on the measure's effectiveness. That's the order of the court. The court is signing that order in open court in the presence of the parties. And I'll ask the parties to acknowledge the court's ruling. Again, thank you everyone. Court's in recess.